Everybody, and thank you so much for joining us at Secular AZ today. We are a nonprofit organization focused on protecting the Constitution and the separation of church and state for over a decade. We have some great programming, and this weekend we will be sharing a booth at the Phoenix Pride Festival with the Arizona chapter of Freedom from Religion Foundation. So stop by and see us and check out the shirts that we have for sale. I'm not sure if you'll be able to see this, but we have the I Read Banned Book shirt, as well as our gay shirts in answer to the Don't Say Gay bills that were being floated around this legislative session. So stop on by. We still have them on sale for $20. And every bit of money that you hand over to us will help us to be able to continue this kind of programming. So stop by. Come see us, check out the shirts, and learn more about how you can help us combat the rise of white Christian nationalism. Excuse me. Next Wednesday, October 12th, we are going to be talking about medical refusals after Roe. I'm really looking forward to that. But today, we are speaking to Dr. Stephen Green. Steve Green is the Fred H. Paulus Professor of Law and Affiliated Professor of History and Religious Studies at Willamette University, where he teaches courses in constitutional law, First Amendment, legal history, jurisprudence, education law, and criminal law in the College of Law, and legal history and American religious history in the College of Arts and Sciences. In addition, Professor Green directs the Interdisciplinary Center for Religion, Law, and Democracy, one of Willamette's centers of excellence. So welcome, Dr. Green. Is there anything that I may have left out of your bio that you would like to add?
No, that's fine. It's very complimentary. Thank you very much. I guess the only thing I would add is that I regularly participate on amicus briefs at the United States Supreme Court. Excuse me. With various cases dealing with primarily church and state, freedom of religion, free expression cases, those types of cases. And the other thing which I may prejudice your audience or not was before coming to Willamette in 2001, I worked for 10 years as the legal director for Americans United for Separation of Church and State in Washington, D.C.
We have I'm sure that many of our members are members of Americans United, probably Freedom from Religion Foundation, American Atheists, and all of those groups, including local groups like Humanist Society and our Reason Riders. We have some really great atheist, agnostic, secular humanist groups in Arizona. So thanks for that addition as well. So yeah, I'm just going to go ahead and pass this off to you and enlighten the people about your topic today.
All right. I was invited to talk about the piece I had in Religion Dispatches back over the summer, kind of in relation to the Dobbs case decision that came down. And in response to the rush by about 15, I haven't checked recently what that number is up to, but about 15 red state legislatures to impose not just draconian abortion restrictions, limiting reproductive freedoms, but also to restrict the ability to have access to contraceptives, the ability to travel out of state, to actually obtain an abortion, the ability to receive certain materials through the mail. And it struck a bell with me. Most of my scholarly writing is in American religious history with a church-state emphasis. And I'm kind of not between books. I have a book that's just come out and one that's under review. And as academics do, we just kind of always try to look for something else to work on. And so about 6 months ago, I started doing research for a new manuscript, a new project about the late 19th century, which I've written on some before, but I wanted to return to because it's such a fertile area, and talk a whole lot about the rise and demise of the free thought movement during that period of time. And I already had some information that I wanted to kind of concentrate on. But one of the things that kept the free thought movement from really taking off, hold on a second, someone's saying they can't hear me. Is there a problem with the
I'm not having any problem with
You're not?
sound, so,
I'm-
yeah, Sandra, I think you might be the only person that can't
Maybe-
hear
Yeah,
Dr.
Sandra,
Green.
maybe try logging out and then logging back in and see if the connection is better for you.
Yeah. Go ahead, Dr. Green.
Okay. Well, anyway, what I was going to focus on was to talk about kind of why the free thought movement in the late 19th century never took off. And in my mind, what really kind of helped precipitate the decline or demise of free thought during that period of time was the controversy over what we called free love, or liberalizing divorce laws, giving women legal equality with men, and also, of course, allowing access to reproductive freedoms during this period of time. And this actually broke apart the free thought movement, and there's a lot of division between the ones on the what I call right or left, the more conservative free thought individuals. They wanted to concentrate primarily just on separation of church and state issues, where the ones who were, I would say, more progressive but more liberal, they really saw free thought as part of just a general overall reform of society, having many social ramifications. And so they were really concerned about expanding on that. And one of the main ones was women's rights and women's reproductive rights. Long introduction. But in doing this research, and that's the focus of what I'm going to do on, you can't not come across, and you can't avoid someone named Anthony Comstock. Anthony Comstock was a self-appointed moral crusader who was able to get himself appointed. He joined the YMCA, which back in that period of time was a very, very conservative evangelical organization, and became their point person to do exposure of vice within New York City. And he got a lot of support from some wealthy industrialists, and they basically bankrolled him. And he was able to get a law passed in New York, which actually authorized, kind of scarily, private organizations with almost police powers to go and arrest people who are engaged in vice. He wanted to do the same thing at the federal level. And the problem is, of course, is the federal government has limited authority when it comes to enforcing criminal laws in states. And the main mechanism that the federal government had for enforcing any type of regulation was through the mails. And so the mail. Okay. And so what he did with some other religious conservatives, he was able to convince Congress in 1873 to pass a rather restrictive law on the mailing of obscene materials through the mail. And then he got himself appointed to be the special agent, the federal marshal, to go and enforce this law. That basically set him off on a close to 40-year crusade of prosecuting and successfully prosecuting about 2,600 people, I believe it was, for various types of vice and obscenity. For him, he was, well, it doesn't say, it's not an overstretch, so he was just a religious fanatic. And so consequently, he saw all types of vice as being very sinful, problematic. You read his writings, he's continually talking about Satan's work out in society and how he's combating Satan. And he has this only almost messianic sense to him, where he's kind of self-appointed by God to go out and uncover vice that exists in society. It wasn't just tilting at windmills in a sense. This urban centers, particularly New York City in the latter quarter of the 19th century, really were in some sense cesspools of you name it. They were overcrowded, they were filthy, there were certainly a lot of poor people, a lot of immigrants coming in, and vice was rampant. Gambling, lotteries, just general theft, saloons were everywhere. Liquor sale was unregulated, drugs were very prevalent. There was many as one statistic I saw, as many as approximately 2,000 prostitutes actively working. There was certainly was a sex slave trade going on, where many young women who would come immigrate would be basically turned into prostitutes by manipulators. And so abortion was rather common during this period of time. And so consequently, I'm not saying all of those are vice, but in his mind, there was all these things that needed to be combated. And so he basically didn't necessarily prefer or go after any one particular vice. He went after lotteries. He saw those as, again, sinful. He went after any kind of what he thought was lurid books, the dime and 25-cent pulp fiction novels, police gazettes, sensationalism type information. He went after artwork, and actually went after the New York Arts League. He tried to prosecute Walt Whitman for Leaves of Grass, Whitman's homoerotic aspects to the Leaves of Grass. He went after Margaret Sanger, which I'll get to that later. So he was willing to go after anyone. He didn't necessarily take preferences of one over the other. But one of the things he did go after with a particular vengeance was that he went after both the abortion trade and went after contraceptives. Now, Comstock, even though he's a very conservative religious person, he is not really going after opposing abortion and contraceptives from a belief in the sanctity of human life, that life begins in conception. My sense is he would not disagree with that concept, but that really was not his main motivation. His main motivation was that he thought that that abortions and the access to contraceptive coverage basically allowed for people to have illicit sex, which he was very much opposed to. And so consequently, he saw this as one of the major concerns and one major things to be battled at this particular point in time. It coincided not only with the quote unquote vice that was going on in the urban areas, it also coincided with, again, a significant movement, a feminist movement, women's rights movement, where you had people who were arguing. Victoria Woodhull was one of the most famous figures, first woman who ever ran for president in 1872, I think it was, who were advocating what was called free love. Free love, some meant just kind of indiscriminate sex, that you could have sexual relations with anyone you wanted to. But for most people, free love actually did not mean that. And for some free lovers, actually saw free love as a form of kind of sexual restraint. What they believed in was that marriage, if it does exist, should be for love, not for just setting up the convenience of marriage. And there should be equality in marriages. There should not be the dominance of men. Men should not control women's property. Men should not have the first say on children in a divorce. Actually, divorce was very hard to come by. And so it was to allow people to kind of come in and out of marriages if they wanted, without constraints. That women would retain their property throughout this. They would retain their rights. There were many within the suffragette movement, the women's voting movement, who were, in a sense, free lovers. Elizabeth Cady Stanton did a famous talk back in the early, before the Civil War, about free love, where she advocated free love. But hers, and for many of them, it was to advance the cause of women's rights. It wasn't for sexual promiscuity. But all that kind of got caught up together. And so the religious conservatives like Comstock were relatively successful in basically tagging everyone who was in favor of women's equality, women's reproductive rights, as engaging in illicit sex, as being immoral. And so this was one of his big campaigns. Long introduction, I apologize. But the reason I mention all this is I started seeing parallels in some of the proposed legislation after the Dobbs decision this past summer by many of the Republican state legislatures, that they were really wanting to kind of go back down this road again, to use, whether it's the federal mails, which the states, of course, do not control, but to try to place restrictions on the ability of people to receive information about abortion access. I mean, think of the famous Texas law that basically has a bounty. If you in any way assist in not just perform an abortion in Texas outside the limited period, but if you assist somebody in obtaining an abortion, then you can actually have be prosecuted in a sense. You can have a civil action against you, a $10,000 fine, For each instance that this happens, just so happens my sister lives in Austin, Texas, about the only decent place to live in Texas. She has 2 daughters who are in college. And I said to her, as soon as the Dobbs decision came out, I said, let me know if this is ever needed, a problem. Oregon has the most liberal abortion laws in the country. And consequently, I'll pay for their airfare to come up and come to Portland, and we will find a facility to get an abortion. And I knew at the time when I was saying it, but then I even said to her afterwards, I think I just violated the Texas law. I think someone could actually go after me and charge me with $10,000 because, or $20,000 since my nieces are twins, for trying to encourage someone to actually get an abortion. So this is a real parallel to what happened in the latter part of the 19th century. Anthony Comstock used the US mails to go after the transmission of information, the sending of contraceptive items, and actually it was pretty common. He went after what he called rubber devices, and that ranged from condoms to dildos, but those were available through the mail. And he definitely thought that you should not have sexual pleasure. So even though dildos had nothing to do with, of course, contraceptive, but that was something he also prohibited. And he basically tied all this up as being obscene. He even went after medical journals. There was a Dr. Foote, who was rather well known at the time, who had written a popular medical journal, meaning not for medical schools, but a popular medical journal to help women understand reproductive options and what they could do. And Comstock went after him, and it was just providing medical scientific information for people. And so, again, this seems like that we have some of these current red state legislatures who are trying to go down the same road to prohibit people from traveling from one state to the other, to maybe try to place some block on the US mail, if they could, to prevent people from gaining access to information. And the bottom line is that it didn't really end well at the end of the 19th century, early part of the 20th century. It left a really bad taste in people's mouths, even among some religious conservatives. Comstock was initially very popular, he had a lot of support, but over time, his methods, he would trick people into sending, he would give false names. He basically did not require search warrants. He would break down doors. His tactics, but also just the breadth of his crusade started to kind of sour people to this idea of authorizing someone. And the whole problem is there actually was not a standard for obscenity at that particular, a legal standard for obscenity at that particular point in time. It actually borrowed from a British case, which did not concentrate on the substance of the obscenity, how erotic it was or something like this, but actually concentrated on whether the material could be used by the recipient for any kind of illicit purpose. And so that was all it was. And then it was up to the jury to make that type of determination, whether it be some person could use a Sears and Roebuck catalog showing underwear as being, sexually arousing or something. And then that would be shown as being for an illicit purpose. And you could go after that. And so it was purely at the behest, the opinion of Anthony Comstock on what was obscene and what was not obscene. And like I said, he saw it go beyond just nude photos. He saw it go into medical journals. He saw it going into the transmission of information concerning contraception, concerning abortion. He went after abortionists. He was actually very proud that of the many thousands of people who he prosecuted. I'm not sure how many he actually prosecuted, but like I said, he convicted about 2,600 from what I recall, that actually 15 of his victims committed suicide. And most of those were women who were abortionists, rather than face prosecution at the hands of Anthony Comstock. And so as a historian, besides being a lawyer, I think the history of our country and just the history in general is kind of a cautionary tale sometimes. It's like the canary in the coal mine that we should not forget, and can kind of see the lessons from history, and can hopefully learn something from those lessons, and be cautious when we kind of rush, as some red state legislatures are doing, to one-ups to do better than the other legislature in their kind of their own moral crusades, because to a certain extent, these are moral crusades that they're engaged into. So anyway, that's kind of the spiel of the piece I wrote, and kind of why I'm working on my scholarship. But I'd be happy to answer questions about church and state generally, about abortion rights, the parallel, the overlap, whatever.
Great. Yeah, I read your article, and one thing that you just said too, so you're in Oregon.
Mhm.
It's funny, it's a place that many of my friends and colleagues are considering relocating to the Pacific Northwest, and it's, because Pacific Northwest, in the past several years have been are more kind of liberal area. My own daughter actually just moved there from Arizona, despite the fact that she just got a degree in education, but it's partly because, the pay in Arizona is really low. I'm a teacher, though I work in the nonprofit industry now. So she's seen me with low pay, but we have these bills too in Arizona that are attacking teachers, their ability to teach accurate history. She graduated with honors from ASU to teach secondary history, and she made the decision, because of the laws that are being passed, that I can't be here anymore. That, in addition to the overturning of Roe, kind of solidified her decision to move away. So, but one thing that you said really struck me, because with this Texas law, you said that your sister lives in Austin, and that you offered to your sister, like, I can help with providing airfare, whatever it takes to, get somebody. Just an offer under that Texas law, just an offer could result in you being targeted for that $10,000 or $20,000 fine.
The problem is no one knows exactly the breadth of this law and how it will be interpreted. Yeah. I think I bought the tickets and sent it to them, or whatever, actually paid for them, done that. That would be a clearer situation. But most of these laws that have been enacted basically are that they that you encourage, or that you assist. Okay, so what does that mean? If a woman in one state says, I'm pregnant, I would like to know what my options are, I don't know, and someone just says, look, Oregon actually does have the most liberal pro reproductive rights laws in the country. Why don't you consider coming out here? And that affects her mind, that affects her attitude, right? Would that be sufficient under these laws? And no one really knows. I mean, if I drive to Texas, pick them up in my car and drive them back, that's a lot clearer. But we don't know the breadth of this, and this is part of the problem. I mean, I teach freedom of expression. And one of the things that's a principle of doctrine in freedom of expression we're always concerned about are laws that we call both vague. The way the law is written, you really don't know exactly what the conduct is that you are prohibited from engaging in. And so what do? You curtail your conduct, even though it may be legally protected conduct, maybe even constitutionally protected conduct, right? And so you don't speak out when you think you should have a right to speak out, because why? You don't know if you're going to be prosecuted. And so in essence, it means that law-abiding people will not engage in law-abiding activity because they don't know what the law means. And then the converse, or the complement to that, is what we call overbroad or overbreadth. And that means where a law basically going after some criminal activity here is written so broadly that it sweeps all this protected activity in it too. And so this is a problem with these new laws. Many of them have not been tested. They are probably overbroad and vague at the same time. And that will then keep people from engaging in what otherwise would be protected activity.
Well, and here in Arizona, now I wish Diane Post is our head of legal, one of our board members. She's not on this webinar today, but we've seen this happen in Arizona since the overturning of Roe v. Wade, where, we have this 1864 territorial ban on abortion, criminalizing the healthcare providers anywhere between 2 and 5 years, I believe is what the law stipulates. So when Roe v. Wade was overturned, almost immediately Planned Parenthood in Arizona stopped providing abortion simply because they just were uncertain. Is it the 15-week abortion ban that was recently passed in our state legislature and signed into law by Governor Ducey? Or is it the territorial ban? And so, there was a court, there was a motion filed in the courts, and at first it was upheld that the territorial ban. Now there's a stay on that. I'm not a legal expert, so I can't really speak to what that all means. But what I know is that now people have now been able to revert back to the 15-week abortion ban, which is still so restrictive and archaic. But it seems too that so much of this is a lack of clarity with the law. And again, as Diane has said, this past legislative session, that these laws right now, these bills that are being drafted are so vague and horribly written that it seems to get tied up in the courts. Is that something that you're seeing in our, states where we have these more conservative legislatures, where they're kind of confused and it has a chilling effect with people to be able to access reproductive health care? And I also just want to at this time say real quick that if you are on this webinar or on the Facebook, please, if you have any questions, go ahead and throw them out there. But going back, so are you seeing a lot of the same thing where there's not a lot of clarity with the laws?
Yes, that's actually the first line of attack, and it's a wise legal maneuver. Because as a result of the Dobbs decision and states then having plenary authority to make determinations about when an abortion can take place, if life begins at conception or whatever, that those are the hardest substantive issues to win on. And so it's easier to get after, to attack a particular piece of legislation by saying, look, Judge, this is just so vague. No one knows what this actually means. There are no definitions, or, this is overbroad. And so consequently, regardless of whether the whole idea of restricting abortion after 15 weeks is good or bad, people just don't know the breadth of the law. And so that's the first line of attack. And I know ACLU and Planned Parenthood are doing that, at least initially in this particular case, because what the Supreme Court just definitively said is that this right that we had seen and respected for 49 years no longer exists. And it just it's mind-boggling. I like I said, I teach constitutional law and I'm a legal historian. It really is about the only instance I can think of where we had the Supreme Court actually take away a right. I mean, I spend a lot of time when I'm teaching my common law classes kind of explaining about the general progression of constitutional rights historically, and the identification by the court and the acceptance within American society that certain laws, certain privileges and rights should be codified, should be made constitutional because of the importance of these. And even though the Supreme Court has been hesitant to kind of expand upon some rights more recently, I also teach education law. And one of the things the court has refused to say is there is a fundamental right to education under the US Constitution, even though 48 states have it listed as a fundamental right under the state constitution. The Supreme Court doesn't want to expand rights these days, but to take away a right that so many people saw as just so crucial and indispensable, and such an anchor too. I don't know what familiar the audience is with the intricacies of the decision, but you may have heard that in a concurring opinion, Justice Thomas basically said, well, the mechanism for recognizing a right to abortion, which was called a right to privacy, and the court later kind of modified that, say, what's a liberty interest right? A right to bodily autonomy, a right to decisional autonomy, that people should be able to make these most intimate decisions about whether to have a child or not between the couple, then also with the person and the physician. But it goes to the heart of what it is almost to be a human to do this, right? That's the same basic theory for gay rights. And we have to understand there are many rights that are not written verbatim in the Constitution. Actually, the right to marry is not listed in the Constitution anywhere. It was just the assumption it would be, right? But the Supreme Court has found that a right to marry is a fundamental right. That's the Obergefell case, the gay marriage case, that the court was willing, which I don't know if they'd be willing to do it now, but the court was willing to find that gay marriage was marriage. And when you basically prevent two people from getting married, it's irrelevant what their sexual orientation is. You're still, imposing a burden on their right to marry. And so, but Justice Thomas, he basically wants to say, hey, everything's back on the table now, not just abortion, gay marriage, gay rights, these other kind of fundamental interests we have at stake.
So, one of the bills that came forward in the Arizona legislature this past session was about banning self-medicated abortions and, denying people the opportunity to be able to get those abortifacients for those self-medicated abortions. Thankfully, it was defeated. But at the same time in Arizona, where, there was just something, a news story that happened recently in Tucson, where a 14-year-old girl was denied medication that would, that's classified as an abortifacient, but that also for her treated her rheumatoid arthritis, osteoporosis. She has a unique condition, and it made, I think, even national news, because the parents and the doctor were, had been prescribing this medication to the child for however long she was diagnosed with this condition. And now, there was a pharmacist, and their argument was that, well, I didn't know because it's now being classified as an abortifacient. So even though that bill didn't pass, is this just a matter of a chilling effect? Is there, I guess I'm concerned about the ability for people to be able to access those medications. What are your thoughts on that with regards to the overturning of Roe and what that means for people? And we're actually going to be talking about this next Wednesday with some panelists here from Arizona about how, and we look at Texas with the PrEP medication, and suddenly now the PrEP medication that helps AIDS patients to be able to, or HIV positive patients to be able to combat the symptoms of that. Like, what do you see going forward with regards to prescription medications, given this recent Supreme Court decision?
Yeah. Well, as I mentioned, I've participated in a couple of dozen Supreme Court cases over my career. And with any big issue, abortion, guns, free speech, separation of church and state, any big issue, you're going to get anywhere from, 30 to 50 friend of the court briefs being filed, to inform the court on all the implications, all the ramifications for a decision going one way or the other. It's before them. So to say that the members of the conservative majority of the court were not aware of what the fallout would be, were not aware of the implications, but like you were just talking about, I find hard to believe. I mean, that's why they have the law clerks. The law clerks read all these briefs, they talk to their justices about it. And so there's not a single one of the members of the majority of the Dobbs decision who did not know what some of the implications would be on this. The other thing that happens, and Justice Thomas is the example of this, the other thing that happens when you have an important decision that comes down from the United States Supreme Court is there are litigants out there who are ready to push the envelope, to move that forward as much as they can. And without a doubt, there are litigants on the right. One of your homegrown organizations, Alliance Protecting Freedom out of Arizona. I mean, they already are looking for plaintiffs to try to push the Dobbs decision as far as they can push the Dobbs decision. The justices in the Supreme Court are not stupid. They know that there are going to be people who are going to take the ball and run with it. Sorry for the sports metaphor. And consequently, this will be what will happen from their decision. Did they intend it? Not necessarily. In the law, they love to think that they can kind of wash their hands. We're only dealing with the case directly before us. So consequently, let's kind of just see how these issues percolate up through the various courts. But they're clearly aware of these implications, that this is going to have that kind of effect. And that kind of chilling effect. Yes, I actually heard about that pharmacist case, right? And I think for every pharmacist who is concerned that by issuing that prescription may be violating the law, is unclear, you at least have one or two pharmacists who are going to use their religious objections, even though issuing that might be. And this is actually the kind of the not the flip side to the compliment we really haven't talked about, is how this is emboldening religious conservative businesses, whatever. We hear this case before the Supreme Court right now, dealing with a web designer, about whether the web designer who does web design for marriages, whether she can refuse to do that for a gay couple. We've seen it within pharmacies, we've seen it within bake shops, bakeries, we've seen it with florists, photographers, you name it. And they're all, because at the same time the Supreme Court has been chipping away at reproductive freedoms, have been really kind of enhancing the idea that to engage in certain activities in certain businesses, to engage in certain activities, I can bring my religious beliefs into that secular operation of my business. And then I can rely on my religious beliefs whenever I find I'm motivated to do so, to say, well, I don't have to do that service. I don't have to provide that service because I'm religiously opposed to that. And so that's going to be the flip side with more pharmacists, more physicians, whomever. They're going to say, no, I'm just not going to serve this community anymore.
Yeah, and this past legislative session too, we saw probably the most overarching religious exemption bill signed into law by Governor Ducey, HB 2507, that essentially allows for state sanctioned discrimination based on religious exemption. We also recently passed, I think it's 2853, another bill that again was signed into law by Ducey, that is a massive voucher expansion, giving $7,000 to private schools, taking away from public schools, putting it into private schools. And I've gone and looked on some of these private school websites. First of all, the cost for a private school tuition in Arizona is about $20,000 on average. So that means that really what's happening is it's a state, a taxpayer subsidy for wealthy families, because there are no longer any restrictions. It used to be for, families who had special needs for their children and weren't able to get those kind of services, somebody who's maybe on the autism spectrum or dealing with severe intellectual disabilities. But now it has been expanded to everybody. And even on the floor of the House, when they were debating this bill, the minority leader, Reginald Bolding, said, so are you telling me, to the sponsor of the bill, that this is now just taxpayer money available to the millionaires and billionaires? And his answer was, well, yeah, because they pay too much in taxes anyway, which is a fallacy. But it's being codified, basically, this blurring of the line between church and state. I don't know exactly where I was going with that, but it's just, I think you said something about legislatures and how important they are to be able to combat this kind of stuff. But really what we're seeing in our more conservative states is they're promoting this kind of stuff.
Yeah, and I'm not to be a conspiracy monger, but there are organizations out there that have their various issues that all are kind of like we're just talking about. And they're providing a significant amount of support, moral support, financial support, just intellectual support, model bills in these particular areas. And you're right, it's I hate to say I was right. And what I'm meaning is that I was actually part of the litigation team back in the 1990s into the early 2000s that did most of the litigation regarding voucher bills throughout the country, and was involved in the case that went before the Supreme Court in 2002, the Zelman case that upheld vouchers. at least I would say that in all of those bills that we were fighting, I was working with the teachers unions and the school boards associations, et cetera, that we were fighting, they were all limited to low income recipients. Right? It was trying to give children who were in failing inner city schools, I'm not trying to justify the vouchers, this is the argument, children in failing inner city schools. I mean, these were the arguments that your Supreme Court Justice Clint Bolick, who was my opponent in many of these cases, I've known him for a long time, he was always making those arguments, you know, and that had some legs to it, had some traction to it. It was kind of an appealing argument, but that's all gone out the window now. And you're exactly right. It's just let's give this, you know, whatever boondoggle to anybody who wants it, notwithstanding what the costs are associated to the public schools. And I mean, Arizona already had one of the most permissive charter school laws in the country that basically almost allowed anyone to set up a charter school. You could be a religious corporation, you could set up a charter school for yourself and your board directors and give preference to your own children. And to now go beyond, because I've looked at the voucher bill, to go beyond and expand vouchers in this particular way is kind of mind-boggling.
Well, and our Arizona superintendent of public instruction, you know, has released information saying that 77% of the people who are applying for these vouchers are folks who never had their kids in public schools, and that there's virtually no oversight. So that means that homeschoolers now, you know, if I've got 3 kids that I'm homeschooling, now I get, you know, $21,000 to be able to spend on whatever I want to, because there's virtually no accountability whatsoever. And when this was being debated in Arizona, it was, you know, like there were stories of folks who were purchasing home gyms, that were taking vacations, and they could say, well, you know, I want my child to be able to discover other parts of the country, or I want my child's physical, you know, health, physical fitness to be right. And there's no real accountability. And then again, going back to the fact that so many of these private schools have it right on their websites. Like if you're a gay kid, if you're LGBTQ, you don't get to go here or work here for that matter. We also know that privates and the law is being put into effect without any accountability. There's no standardized testing. There's no review of curriculum. There's no school board to govern. And arbitrarily, children can be thrown out and people can be refused employment because there's just no accountability. So it's just kind of shocking to me that so many people kind of buy into this, but I guess that's where we are as Americans. One thing I wanted to go back to, because, you know, speaking of Justice Thomas's opinion on this, and this is something that actually my kids asked me about, and I'm no legal expert. So one of the things that they said, it was interesting to them how Justice Thomas left out interracial marriage. So like we can see in the future that gay marriage could be threatened by the opinion that came out. What other things could be in danger because of the verbiage of the opinion and you know, the overturning of Roe?
Yeah, well, I mean, just comment on that. I mean, I probably a couple of reasons. He did not mention interracial marriage. One, his wife is white, and so that would be self-defeating for him to a certain extent, but also just legally. Race has always been considered to be kind of the super protected right, super protected interest. And the point is that the 13th Amendment expressly says badges and incidents of slavery. And one of the prohibits it, and prohibits not just state actors, but anyone from engaging in that type of conduct. And so consequently, to go down the road of interracial marriage has additional constitutional safeguards. And so he was actually being legally, constitutionally, he was right that by not mentioning that there is a difference that exists. Yeah, I mean, you know, you were talking about private schools. I mean, another thing that they discriminate against are people with disabilities, right? And so you have you have the court recognizing, not necessarily that being disabled is what we call a suspect class, entitled to extra protection. But they have certainly been very supportive of federal and state legislation in order to provide these additional protections, additional accommodations that exist. And so by virtue of him basically implying that unless it's written expressly in the Constitution as a protected interest, you therefore, the states will have the free reign to basically regulate it the way they want to regulate it. Has significant implications just beyond this right to privacy that exists. And so many of us are concerned, like what you're just talking about with the private school legislation in Arizona. It's an open door for various forms of discrimination of groups of individuals who are not in protected classes necessarily. And so far, the Supreme Court has now held that LGBTQ rights are a protected class, people who are LGBTQ. And so consequently, when it's going to come to a balancing between them and then someone, once again, who has a religious objection to serving them, and the court is now very, very protective of those free exercise rights, and that is written in the Constitution, there's just going to be no question how it's going to have these types of effects on services throughout the country. And it's an extremely kind of troubling trend that we are seeing in so many areas.
So I'm sure that you're somebody who follows the Supreme Court docket. What cases, coming up on the agenda for the Supreme Court are giving you the most consternation right now?
Yeah. Well, I'm curious to see how the court will deal with this web designer case, and that's actually it's a hard case. It's a closer case.
Wait, can you maybe real quick? I'm sorry. Could you maybe tell us what is the name of that case?
Oh God, you're gonna ask
I'm
me.
sorry, I don't mean to put you on the spot,
Yeah.
but that's fine. It's fine. We can probably
She
look it up.
has a very strange last name. It's what is it? I'm sorry. It has 3 letters and then it has a number by it. I'm trying to think what it is. I can get it to you. Yeah.
Oh, look, Lindsay actually just put it in the chat, so I'll make sure I put it in Facebook as well, but the link is there. So whatever it is, I haven't even heard of this one, the web designer one. Let's hear about that.
Yeah, well, just as background, we had about 7 years ago, I guess it was. Yeah, 7, whatever. We had the Masterpiece Cake Shop case, which was out of, maybe not that long ago, whatever, out of Colorado, where the baker refused to do a wedding cake for this gay couple. Even though he said he would otherwise sell them a cake, he otherwise would serve them, blah, 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 right? And it was the Supreme Court, and the Supreme Court sided with him on a kind of a technical ground. They found that the Colorado Human Rights Commission had particularly kind of discriminated against him, saying that religion is a bad thing, a religious reason to object to it is a bad thing. Didn't necessarily say whether the public accommodation law, the non-discrimination law, would prevail or not prevail over a religious objection. They kind of kicked that can down the road. But that was when Justice Kennedy was on the court. He actually wrote the opinion, and Justice Ginsburg were on the court. And so we had a significant change in membership now. This case is a web designer, and what she does is she designs web pages for upcoming weddings and for other things, but primarily upcoming weddings. Okay. The argument they made in Masterpiece Cake Shop and have made in some of these other cases, like the florist case and things like that, is that these business owners who have religious objections are engaging in artistic activity. And so consequently, there should be artistic freedom, but also it's expressive. And so what the state is doing when they're imposing these restrictions on them or telling them to abide by the non-discrimination laws is that they're doing what we call compelled speech. We're compelling them to make a statement, to make a affirmation with something that they're morally disagreeing with. I find that to be somewhat of a weak argument because the primary business of being a florist is to do floral arrangements. You're giving a product. Same thing with being a baker, right? You're making a cake. Any speech related to that is certainly secondary or ancillary. It's really not major to it. The problem with this wedding designer case is it is pure speech. When you're making a web page, it's just expression. It's no other product beside you. You're not getting a physical cake with it. You're not getting the physical flowers. And so I have very little doubt the Supreme Court will find that her free speech rights will override, this case also comes out of Colorado, will override the non-discrimination law. My main concern, and to a degree as a First Amendment person, I can kind of appreciate if that's where the holding goes, because I don't like compelled speech. What I'm mainly concerned about is all the additional verbiage we're going to get out of some of the members of the court. The concurring opinions by Justice Gorsuch or Justice Alito or Justice Thomas, who are going to say, oh, and by the way, that type of stuff. So that concerns me. The two voting rights cases that are up before the Supreme Court, right? I mean, whether this idea that a state, this is the North Carolina case, the state legislature, only the state legislature is the one to make the ultimate decision about the voting that's going on. And even the state Supreme Court cannot find that the state legislature's actions are unconstitutional. I mean, it's just a fundamental principle in Americans in our government, in the judicial system. So we have something called judicial review. If a legislature passes an unconstitutional law, we go to the courts and the courts review to see whether it's consistent with either a state or the federal constitution. But what the proponents in this case are saying is because there's phrasing in the 14th Amendment about it's up to the state legislatures, or just as the state legislature shall, that they're reading that literally as saying only the state legislature can make the ultimate decision about whether these voting restrictions are unconstitutional. And that's like, you know, letting the fox guard the hen house, right? They're the same people who wrote the law, taking away people's ballot access, etc. And now they get the ultimate say in it, whether it actually does deny people the right to vote. That is a very troubling case. The other case is dealing with part of the Voting Rights Act and how far the Voting Rights Act can do. And there's really not much left of the Voting Rights Act, unfortunately. And then I'm concerned about the affirmative action case. These are two cases. One is out of Harvard. So it's actually not a constitutional case. It's a Title VI case, which is federal funding that goes to institutions. So Harvard gets a lot of federal funding, obviously, for scientific development. But the other case is University of North Carolina, my alma mater, where I got my Ph.D. And that is a public institution. And it's whether you can use race in any way at all when it comes to admissions policies. And what the court held when more liberals or moderates are on the court is race could be one of many factors. It can't be the determining factor. It can't be the tiebreaker. But when we're talking about diverse student bodies, is race an issue that leads to diversity along with socioeconomic, et cetera, and the court said, yeah, of course it is. That makes sense, right? What the litigants are charging in this particular case is any use of race, regardless, is going to be unconstitutional. We need to be race blind. And unfortunately, I'm feared because the court took this case that there's a majority of the court who's going to say, you just, race is irrelevant. And I can remember a nice closing statement by Justice Blackmun, who was on the court in one of these cases. He said, in order to overcome racism, we have to consider race. You can't turn a blind eye to race or to racism. You have to recognize it's endemic in our society. And the only way you recognize it's endemic in our society is understanding the issues and the problems that are continuing with race. And so consequently, but this is where the court is going.
So I think it was Justice Kagan who, you know, came out with, and I don't even know, but she basically was saying this court no longer has validity. It has become a partisan court. And I think that, you know, for me especially, I've always thought of the judiciary as that kind of blind eye with regards to our political system, and that the judiciary are the ones who should just be interpreting the Constitution. And in her writing, she said something about like now it's become a free for all, and that these folks are politicking from the bench basically. And it's not just the Supreme Court. Even in Arizona, I don't remember what it was, probably back in 2014, 16, something like that. Governor Ducey expanded the court and basically, handpicked the extra 3 judges. And now we have this massive majority with our Supreme Court. Like, what are your thoughts on the validity of the judiciary, not just at the Supreme Court level, but throughout the United States and the different levels of court?
Yeah, I think it's really harming it. And it actually makes it hard to teach constitutional law in law school, because you have people over in the political science department across the street from where my law office is, who are always saying, well, the Supreme Court has always been a political institution. The law has always been very political. And I agree. I teach legal philosophy too. And so there's no such thing as truly secular aspects to the law. There's always going to be something there. But at least we try to ensure that there is something we call the rule of law, that we adhere to precedent for the purpose of predictability and legitimacy. And you do try as much as you can to put aside your own personal beliefs about an issue if you're a judge, and try to decide based upon the facts and the understanding of the law. And unfortunately, yeah, I think that is really under threat these days. We mentioned Justice Thomas several times. It's really, everybody's now saying he really is the most powerful person on the Supreme Court now that Justice Scalia has left. And he will end up being the longest sitting justice ever, probably in history, because he was appointed in 1991, and he's only in his early mid-70s. So he can do another decade on the court without doubt. And he has been in it for the long haul. Quite clearly, he has been in it for seeing where he could finally lead the court in a particular direction. And we all know, I've heard a whole lot in the news about his wife's activities, very political activities. And so I am not to diss Justice Thomas, but unless these people don't talk about anything at all over the dinner table, we know there's a lot of discussions going back and forth, right? And so this is very disheartening, because we would like to think the law is an independent institution and is going to be that safeguard for our American freedoms and democracy itself. And that is really more and more under question these days, and that's really a shame.
So
leaving it on a really sad note, I'm sorry.
No, like that's what I was gonna say. So we do only have 2 minutes left, and we have a very engaged group of people who are here on the webinar who will access this recording later on. Many of them are probably actively canvassing or making phone calls to try to influence elections throughout the state of Arizona. So given the very depressing note that you just landed on, what would be your advice to folks who are watching this in real time and thinking to themselves, I can't believe this is happening. What can I possibly do to change the trajectory? Is there something that we can do as individuals to protect the Constitution and to, support the idea of democracy in the United States?
Unfortunately, the composition of the Supreme Court as it is now is going to be pretty set for a while. What that I think means, though, because the court is sympathetic more to federalism, meaning giving more discretion rights back to states, right, is that is really, I think you said, Jean, just earlier about this. This is really, I think, where the battles are. As much as I'm concerned about the composition of Congress, I'm very concerned about state legislatures. And progressives, liberals have been kind of behind the in paying emphasis to that and not taking anything for granted. I will be out canvassing tomorrow for my Democratic state senator and some other people. You can't even take it for granted in this state like Oregon that is super blue. And it is one of these things that every vote does really count. And we can't be complacent about that. It's going to take a while to kind of reverse course on some of this. But if we can ensure that we have more progressive state legislatures. I'm hoping the court will adhere to what it has been saying, that it will defer to state legislative judgments more. And so you can assume your rights are going to be there. And the other thing I think is to continue to protest, continue to object, continue to make your voice heard. I know it's frustrating, but don't become complacent, because then the conservatives will use that as a sign that there really is not that type of opposition that exists. So banging your head against the wall, I guess, but still, you need to be out there and making noise.
Well, you heard it here first. Well, maybe not first, but you heard it here. Thank you so much, Dr. Steve Green, for joining us today. Follow his advice, get involved with local legislative races. We didn't even talk about school boards and the craziness that's happening in school boards. But if you've got a good school board candidate in your district, by all means, support them as well, because they are at the very bottom of the ballot. So thank you so much, Steve. I really appreciate your time today. I found this incredibly informative. And I find it terrifying that in 2022, we're reverting back to what, 1873. It's absolutely mind-boggling.
Yeah, it is. I actually have a 14-year-old daughter, and I didn't think I would have as much concern for her future in so many areas as I have today. But anyway,
Yeah.
Keep up the good work.
We're all suffering from kind of a collective anxiety and traumatizing events one after the other since 2016, whether it was the pandemic or the judiciary or whatever else. So thank you for continuing to write about these really important topics. Thank you to everybody who was able to come today. I appreciate you, and heed Dr. Green's advice, and please make sure that you get involved beyond just voting and support those candidates and those ballot initiatives that really need you. So thank you, Dr. Green.
My pleasure.
All right. Have a great day. Have a great weekend. Bye-bye.
Bye-bye.